Good afternoon, everybody, and welcome to today's session. Thank you for joining, and it's nice to see so many people have decided to join in this afternoon for what I hope will be an interesting session. And I'm hoping we can make this quite interactive, or as interactive as we can make it over the screen. So feel free to jump in with any questions at the side there, if anything comes to mind throughout. Just to give you all a quick introduction for those who don't know me or Altamimi. Altamimi is the largest firm in the Middle East. We currently have 17 offices across 9 countries. Mainly offices are based in the GCC countries, but we do have some in other countries such as Egypt and Jordan. We are a full service firm, so we provide advice on pretty much everything, including employment and incentives, which is my department. My name is Natalie Jones, if you didn't see it at the beginning, and I'm a senior associate in the employment and incentives team. Again, the team is the largest specialist employment team in the Middle East. We have 11 specialist employment lawyers at the moment across the UAE, Bahrain, Saudi and Egypt. In terms of my practice, I advise on everything to do with employment, from onboarding to exiting employees, but usually have a particular focus on pensions, investigations and employment audits. Probably like most employment lawyers at the moment, I'm focusing a lot on queries that are arising in the context of the current situation, and there are a lot of those questions, so I'm hoping to deal today with a lot of the issues that are coming up, so that you can see what type of issues are arising and how they should be being dealt with. Just to give a little overview about what we're going to be talking about in this session and what I'm going to cover. I'll give a couple of opening remarks, nothing too amazing in there, nothing too new probably for most of you, but just to set the scene. We'll then have a look at travel restrictions and movement. Again, probably more scene setting, but it does go to some of the issues that we have in relation to employees and particularly recruitment. So it's an important one to cover off. Then we'll have a look at health and safety and quarantine, and that's something we're getting more and more questions on as the current pandemic seems to be moving forward in terms of how to protect employees and what are the obligations around allowing employees to stay at home, etc. We'll then move on to remote working, and I would hope to give some practical insight there into the type of things that should be given priority at this point and how to make remote working work in the context where most people are not remote working regularly. So it's quite an interesting time for that. We'll then move on to possibly the topic I'm getting the most questions on from clients at the moment, which is cost-cutting measures. So issues around unpaid leave and around reduction in salary, etc. So that will probably take up most of the time. And then hopefully we'll have some time left at the end for some questions and answers. So if anyone has anything throughout, please feel free to jump in, or otherwise we can hopefully have time at the end to cover any issues off. So as a starting point, as I said, I will kind of set the scene a little bit with travel restrictions and movement. But before that, just to give some context, I read an article yesterday that said 2.7 billion people, or 81% of the world workforce globally, is being impacted by the current situation. And up to that amount, so 2.7 billion people are having to work either partly or fully from home, because their entities are, again, either partly or fully closed. That's a massive number, and it just goes to show how much of an impact this situation is having on all of us in the context of the workforce. So whether as employers or employees, I think everyone is being impacted by this at the moment, and so it's really important to understand what our obligations are and what we can do to kind of protect the business and protect employees at this point. In the UAE, obviously, there are steps being taken to hopefully protect all of us to the extent possible. And they have started, or did start with, restrictions on travel So I think most of us will be aware that most flights have now been stopped from coming in and going out of the UAE. There are, of course, a small number of repatriation flights that are bringing UAE national employees or individuals back to the UAE so that they can be home. Generally, nobody else is able to enter. And I know there are some, I've heard stories anecdotally of some people being able to return to the UAE, I think on humanitarian grounds, but everybody else is basically, once they leave the UAE, they're not coming back for the time being until the current position is changed and the restrictions on flights are lifted. Along those lines, visit visas and entry permits have been suspended. So new employees are not able to get into the country or to get an entry permit to come over. So that has an impact on recruitment, and we'll talk about that shortly. But it's important to bear in mind at this point in time, basically, that anybody outside the UAE is pretty much not coming back in, and clearly that will have an impact on employees. Again, the UAE has other measures that it has taken throughout the country, and they look mainly like restrictions on workforce and in terms of movement around the UAE. So currently there is still a resolution in place, number 281 of 2020, which restricts the number of employees which can be working from an employer's premises. So the number of employees should not be more than 30%. That's still in place all across the UAE, but obviously in Dubai, there have been further restrictions implemented which have somewhat overtaken that provision. And so at the moment, the position in Dubai is a 24-hour lockdown, effectively, meaning everyone is required to stay at home. They can leave the house with a permit for certain specific reasons, including grocery shopping for essential items and going to get tested for COVID-19. The slight exception is employees in the vital sectors. So, for example, those working in hospitals, etc., they are obviously allowed to leave the house to go to work. But again, they do have to work in a vital sector. For those who leave the house without a permit and who are not working in vital sectors, certain sanctions and penalties can be applied. Abu Dhabi and the other Emirates haven't followed suit to that extent quite yet, but there are similar restrictions in place in terms of maintaining social distancing, etc. And both Abu Dhabi and Dubai have now implemented restrictions on workers entering and exiting the Emirates. So perhaps that's a sign that things are stepping up, or the measures are going to be stepped up, and that's something to bear in mind. Insofar as recruitment considerations are concerned, I mentioned already the impact of the restrictions on flights into the UAE and the issuance of certain visas and entry permits. Clearly, that's a big issue for some employers, and I think at the moment, obviously, recruitment is probably not as buoyant as it possibly was at one time, but there is still recruitment happening. Where that is the case, companies will obviously have to be mindful of whether they're recruiting internally or not. And if the recruitment is not internal, there will obviously be an impact on timing for start dates and that kind of thing. Where there is recruitment internally, the Ministry of Human Resources and Emiratisation and the Free Zone authorities are still working, and we understand they are still issuing visas, work permits, labour cards, etc. But of course, that is likely to, the process is likely to take longer than it possibly would have otherwise, because of course, remote working is in place even at government level, and there's obviously a lot going on in the background, and the governments have probably more important things to be dealing with possibly at this time. So in reality, although there is recruitment happening and work permits, etc., are being issued, I think it's important to bear in mind that the process is going to be slower, and that would have to be factored into any recruitment considerations. In terms of health and safety, so once obviously employees are recruited, or for the employees that are already in the workplace, consideration would have to be given to what type of health and safety measures should be in place at this time. There is a general obligation onshore in the UAE labour law that basically says all employers must provide adequate protection against hazards of occupational injuries and diseases for their employees. There's also a provision in the DIFC and ADGM regarding protection and providing health and safety considerations for employees insofar as practical. But either way, in both situations, it's likely to be that employers continue even at this time to need to think about health and safety for their employees. And I think possibly more so with the current situation. So obviously the position in the labour law and the relevant regulations in the free zones will continue to apply. But in addition to that, there are specific issues which will additionally need to be thought about. So for example, if employees are coming into the workplace, are they having, for example, their temperatures checked? Are they being provided with masks, with gloves, etc.? And so far, we haven't got, in most workplaces, we haven't got a general obligation to provide the kind of gear that I just talked about, so gloves, etc. But obviously it's a question for employers whether they want to go the extra step to provide those to show their willingness to protect health and safety. And I think that is an important consideration at this time where employees are in the workplace. Now, clearly most employees are working from home, and so in terms of practical measures and recommendations, if employees are not working from home, probably consideration should be given to whether they can and whether they should, particularly for employees who perhaps have chronic conditions, who are pregnant and so on. So in line with one of the resolutions that was issued that said to give priority to those employees, I think even where the resolution doesn't apply, probably priority should be given to those employees to show again that the employer is concerned sufficiently with health and safety and with the protection of its employees' health and safety. It's also important to put in place other measures. So for employees, making them aware of what's happening and what the current best practice rules and guidance are, and also to encourage them to report if they are unwell or if they've been in contact with somebody else who's unwell. And now we do have federal legislation or federal rules insofar as reporting if somebody is unwell. So there is a positive obligation now to report if someone is suffering from the coronavirus or if there's any suspicion of that. So it's important to advise employees that they should be bearing that in mind. A question that we're getting a lot at the minute, or that I've had a number of times, is about how to deal with quarantine. So clearly employees, or rather more broadly individuals in the UAE, are being asked to isolate if they suspect that they have the coronavirus, if they have tested positive, of course, or if they've been in contact with somebody who is suspected or has the coronavirus. Now that will only work if the employees are not worried, I would think, about losing income, etc. at that time. So where employees are self-isolating, or where employees are being encouraged to self-isolate, I think it's important that the business thinks carefully about what message it's sending in terms of salary, for example, and other considerations. So clearly, if employees are unwell, if they test positive for the coronavirus and they are sick, they would report sick leave in the usual way and would therefore be entitled to sick pay in accordance with the labour law, DIFC employment law, whichever relevant law, and also in line with the company's policies. It gets a little bit more murky where the employee hasn't tested positive yet. So if, for example, in the scenario that I just mentioned, where employees come into contact with someone who may or may not have tested positive, and they then want to self-isolate, which of course is good practice and we're being told to do that. Clearly, employees at that point are not necessarily entitled to sick pay because they're not sick. But I do think it's important for companies to have a think about whether employees will continue to be paid if they are self-isolating. And of course, that question kind of goes away somewhat if or in the case of employees who can work remotely, because then there's no real impact. They can continue working, they're just isolating at the same time. The issue is going to be greater where employees are not able to work from home and are self-isolating. And I think it's at that point a question of weighing up the requirement for employees to self-isolate and the requirement to be seen to be doing the right thing and to be doing the right thing for employees, versus not wanting to encourage all the employees to follow suit and end up in a situation where no employees are working and everyone's having basically 2 weeks holiday. So that will, of course, depend on the company's position and will be clearly case specific. So it's important to look at each case on its own merits. But I do think overall that there has to be some general principles in line from the company's side, just so that employees know what to expect and they know that they're encouraged to comply with the government guidance insofar as self-isolation is concerned. On the topic of remote working, clearly most companies in the UAE don't naturally have atypical working arrangements in place. And perhaps one positive of the current situation, if we can find one, is that possibly we're moving more towards a flexible working setup across the UAE, out of being required to do that rather than by choice. But still, it's possibly a positive move in that way, particularly because the government is now recognising remote working, which it hasn't previously, and I will come on to that in more detail shortly. But of course, in terms of remote working, there are always going to be practical issues. So I think the first and the most important one, of course, is whether employees can actually do their job at home. So are they in a role where they can manage things from home? And in some cases that just will not be the case, and unfortunately then employees just cannot work from home with the best will in the world. But assuming employees can work from home, there are other considerations to bear in mind. So for example, it's important to have in place or put out regular announcements to employees about what's happening within the company, what its goals are, anything they should be aware of, and also have the policies underneath that to support what's happening. So how many hours a day is the employee supposed to work, usually in line with their employment contract, but are those hours all together, or because they're working from home, can they pick their own hours, subject to completing the minimum number of hours in their contract? Or is it the case that they have to be available between set specific hours? Can the employees work from home, or can they work remotely from somewhere else? Clearly, that's less of a consideration for us at the moment in light of the current circumstances, because most employees should be at home. But for those, if that wasn't the case, and possibly a point for going forward, if employees are able to work elsewhere, is the company happy with that? And that will lead on naturally to having the right equipment to be able to work elsewhere. Now, if the employees need their laptops, for example, they will probably need to be somewhere where they can sit properly with a laptop. Do they have internet everywhere? And is that internet sufficient to support the download or other speeds that the employee needs to do their work? And again, that might dictate where they can do their work from. That leads, I think, onto the confidential information point, which is clearly that one of the most important things for most employers is going to be whether their confidential information is protected sufficiently while the employee is remote working. Now, clearly, again, that will come back to if the employee is working, for example, in the middle of a cafe with a computer open, screen out, having conversations in public that perhaps the employer wouldn't be comfortable with everyone seeing or hearing, that's a real issue. It presents a problem, and it's something that should be dealt with in the policies that I referred to at the beginning of this part. And just generally, even if that is not the case, if the employer is happy with the employee working from anywhere, and their systems are capable of doing that or allowing that, consideration also needs to be given to things like how are documents being stored? Has the computer got a password on it? Does the screen automatically turn off after a certain time, etc.? So that's something internally for the employer to work out, and also then to communicate that properly to the employees to make sure that they are following any protocols or any policies in that regard. Again, we've talked about health and safety, but I think it's important again to mention it at this point, just in the sense that health and safety isn't usually a particular concern where employees are working from home, because the company doesn't have the right to go in and do, for example, health and safety checks on an employee's premises. But I think it is worth recognising that the resolution I mentioned earlier, number 281 of 2020, does say that an employer, in circumstances where an employee is working from home, is required to provide the necessary tools, but is also required to ensure that the employee is working in a safe environment. In reality, I'm not sure quite how that would work, particularly now, where employers clearly can't go to an employee's home to check everything. So in reality, I think that's probably not happening, but it is something to be aware of insofar as it is an obligation that's set out in the resolution. And finally, I think this is the question I get every time I have a question about remote working. I always get the question about how do we check an employee's working properly? How do we know if they are doing what they should be doing? And there's not a one size fits all for that. Clearly, it depends on what the employee is doing, on the sector, on what KPIs there are in place, etc. But generally, I would say it's important to put in place clear measures as to how productivity will be measured. So is it a number of hours per day, like lawyers? Is it that they have to get so many of a certain or so many calls out a day, if it's sales, for example, or so many contracts finalized, etc. So that will be very specific or very case specific, but it is worth putting your mind to, as an employer, putting your mind to what systems will be in place and how measures will be happening. And I think it's also important to have a think about how you keep your team working together. So is it that you have perhaps regular team meetings on Microsoft Teams or Zoom or whatever the platform of choice is, but how do you keep everyone talking together? How do you check everyone's still okay? Checking workload, etc. So it's something to have in place, but have in place in a way that works for what your team are having to do, so that it's not overly burdensome, but also keeps you aware of what's going on. Naturally, I think at this point, even for most companies have remote working systems in place. They are keeping an eye on employees. They are doing whatever they can to ride through this current situation. But in lots of cases, employers are naturally having to turn to cost-cutting measures, unfortunately. And those measures, until recently, weren't really addressed by the local laws and the local authorities. But as a result of Ministerial Resolution 281 of 2020, which was issued towards the end of March and has been in place or enforceable since the 26th of March, those measures for the first time have been set out in a resolution and have been therefore recognised by the authorities. It's good to see that they have been recognised, but I think it's also important to remember that the UAE labour law is still in place in its entirety, and I'm seeing or have seen a lot of articles that suggest that this resolution somehow amends the labour law. It doesn't. The labour law is still in place, it's still enforceable in its entirety, so there is nothing here that would change the labour law. But this does provide additional points that the labour law possibly hasn't considered, or guidance that is just not available anywhere else. So the main measures are around unpaid leave, salary reductions and redundancy, which again haven't ever been considered before here. So it's a step, a move forward, and it's one that lots of employees are looking at the moment. Insofar as the resolution is concerned, it doesn't apply to everyone in the UAE. It applies to employers who fall under the remit of the Ministry of Human Resources and Emiratisation. So strictly speaking, it doesn't apply in the free zones. Just as of itself, it doesn't apply in the free zones. It clearly doesn't apply in DIFC or ADGM, which have their own legislative regime anyway. Some of the free zones, having said that, have decided to adopt the resolution. So, for example, in DMCC. And also some of the free zones, as I understand it, are going to bring in, so they're not going to apply the resolution in its entirety, but they are going to bring in something similar, or ask the companies registered under them to comply with something similar. So to give an idea that the resolution, it covers off each of the points that I've already mentioned. It also has in place several other points or guidance to be complied with. But I think taking it step by step, lots of employers are looking at paid leave, or employees utilising paid leave at this point. Outside of the resolution, in any event, the labour law provides that employers have the right to place employees on paid leave at their discretion, as long as they don't split it into more than 2 parts. So, for example, if an employee has 30 calendar days or 22 working days of paid leave per year, the employer can say, we will split it into, for example, 10 calendar days and 20 calendar days, or 15 and 15, set the dates for it, and then the employee has to take leave on those dates. Clearly, from a personnel management point of view, it's better to ask employees when they want to take leave. And that can be within a framework of saying the leave has to be taken within a certain period of, for example, 6 months, or it has to be taken before, I don't know, September of each year, or else otherwise it will be set for them. And it can also be set alongside a use it or lose it leave policy, and that's quite a common approach. At this point in time, I think the vast majority of companies are saying to employees, we want you to get your leave taken now while it's quiet, before they move on to other more drastic measures. And that would be, for example, unpaid leave. Now, the resolution that I mentioned does provide for unpaid leave. I think it's important to recognise that unpaid leave is happening anyway, irrespective of the content of the resolution, and it has been happening for some time. The difference now is that the resolution specifically provides for it, and the resolution therefore supports employers in their decision. What it doesn't do is say that employers can unilaterally place employees on unpaid leave. It does still say that employees have to consent to the position, which clearly won't be the case in all circumstances. So sometimes, and I have heard this today, just earlier today, that some employers are struggling with this because employees just refuse to cooperate with or accept unpaid leave. Clearly, there's no way to force employees to take unpaid leave. But from what I've seen over the past couple of weeks, most employers that are dealing with unpaid leave successfully are the ones that are consulting properly with employees in advance and are being very transparent with their employees that in reality this is in an attempt, or unpaid leave is being used in an attempt to avoid more drastic measures and to protect not just their business but the employees going forward, so that once there is some recovery in the economy and in what's happening at the moment, there will still be a job left for those employees, which may not be the case if cost savings or cost cutting measures are not successful. So I think, again, it's important, it's all about the conversation that is being had with employees and how these matters are being approached. Similarly, the resolution also provides for salary reductions, both short-term and long-term. Both, again, require the consent of the employee, and it is pretty common at the moment for salary reductions to be happening. Quite helpfully, the ministry has provided a document which should be completed where salary reductions take place. It's very basic and just requires the parties to set out what's happening and over what period, start date, end date if known, and have both parties sign. The resolution requires 2 copies of that document to be executed. I would probably suggest that 3 copies are executed, just to make sure that there is one for the employee, one for the employer, and then a spare for the ministry, should the ministry decide it wants a copy. And then everyone's still got their copy so they know what's happening. And again, that applies to both short-term and long-term reductions. And the same concepts or the same issues that I raised in relation to unpaid leave will of course apply to the salary reductions. So for example, getting employee buy-in is a massive issue, and it's something that needs to be considered before steps are taken, so that reductions are not imposed and then it becomes clear that there are all sorts of issues in the background, because ultimately without employee consent, making reductions again in situations where you don't have employee consent amounts to lack of payment of salary or unlawful deductions, and can expose an employer to claims in the labour court. So it is really important to make sure employees buy into what's going on. And I think it's also important that the least drastic measures are taken where possible, or as a starting point, and that is reflected in the resolution, which says that the steps should be taken gradually, so paid leave, unpaid leave, salary reductions, etc., in that order. It's not clear from the resolution or otherwise how that will be dealt with if matters are not addressed gradually like that. So that remains to be seen, and I don't think that the ministry will be too involved with that for the time being, again because there's so much going on, but in due course it will be interesting to see what happens where the process is not followed in that way. Possibly the most interesting point that's come out of the resolution is an apparent recognition of the concept of redundancy. Now I say apparent because the resolution does not specifically say that it recognises the concept of redundancy. Instead, it simply makes it outlines practical steps in circumstances where an employer finds itself in a position where it has a surplus of employees. Now, clearly, we all understand that to be a redundancy situation, but just to be clear, redundancy is not specifically mentioned. What the resolution says in relation to that situation is that if an employee is dismissed, they should have the option to be placed on the ministry's virtual job database. So the idea is that all of the employees' information will be put in the database, and if another employer is looking for an employee, it can go on, see that employee's details and potentially onboard that employee. So possibly useful in the context of those suffering from job losses. But probably even more importantly than that, the resolution goes on to say employees who are, again, effectively made redundant will be entitled to certain payments post-termination. And that's the first time that's happened. So ordinarily, where an employee is dismissed, they are entitled to payments up to and including the termination date, and not really anything after that unless it's agreed specifically between the parties. Now, the resolution says that an employee who is dismissed, where there is a surplus of employees because of the current situation, the employee is entitled to receive allowances and benefits post-termination until such time as the employee's residence, the employee can leave the UAE, so the residence visa is cancelled and they can leave the UAE, which again is difficult at this point given the lack of flights. Or the employee finds alternative sponsorship and gets a new job, or the resolution is retracted. Clearly that won't happen until all the measures are being taken back by the authorities and we're effectively back to normal. So this is really important for employers to recognise for two reasons. One is that if redundancy is being looked at for the purposes of cost saving, which it naturally will be, it will not necessarily provide the cost saving measures that might have otherwise been expected. So it won't automatically bring everything to an end on the termination date, and therefore consideration should be given to the fact that amounts will continue to accrue and payments will continue to be paid to the employee, which wasn't the case before. The second issue to bear in mind is also that although the resolution refers to these provisions, as I mentioned before, the labour law has not been amended. So we still have a situation where, at least in theory, the dismissal of an employee should be on the basis where we have an unlimited term contract of a valid reason, which is not necessarily including redundancy. So we could end up in a situation where employees are dismissed possibly contrary to the labour law, in a situation where also the company has acted in accordance with the resolution. Again, we don't know how that will all be tied together. So it remains to be seen, probably in due course, once the courts are back to normal, what view the courts will take on this, and particularly in situations where the labour law hasn't necessarily been complied with, but the resolution has, and whether the courts will take a more sympathetic view on employers in that situation, particularly if the employers can show that they have genuinely been in distress financially, and that without taking the steps that they have made, they would otherwise have perhaps gone into liquidation or experienced further distress. And I think that's also maybe where it will come into importance, whether the employer has followed the gradual measures set out in the resolution. So if the employer can show that it has followed every step exactly, and has made all provisions that it can make to save the employees and to avoid more drastic action, I think that's where the court may well have more sympathy. But in circumstances where, for example, a company moves straight to redundancy without having tried to follow other measures, it may not be the case. But again, that's my thought on it rather than a guarantee, because we haven't seen the courts address this matter yet, so we don't know quite how everything will sit together. So in terms of my input, I've tried to keep it brief, and that brings us to the end of the kind of set out input. So if anyone has any questions, I think there is a little box we can ask questions in. And I think there's a few questions there, so I'll go through the questions that are there now. And then if anybody else has any questions, obviously time permitting, feel free to put them in the question box if you know how to use it. And I'll try to deal with as many as possible. If there are any questions that you don't want to put in the box in this forum, my email address will also show up at the end of the session, and therefore you can contact me directly if that's preferred. But for the time being, the questions that we've got, the first one is, apart from the progressive measures listed in the resolution, and in case of mutual agreement with the employee, can a part-time arrangement be secured before the full usage of paid leave? Also, how should it be treated? That end bit is not coming up. But potentially the parties can agree to a part-time arrangement. Obviously, there has been over recent years, or the recent months even, recognition of part-time working to some extent. So if the parties agree to that, they can proceed on that basis. And I'm aware that some companies have proceeded with that. And again, like I said before, we don't know what will happen if the process as outlined in the resolution isn't followed exactly anyway. So it could be that that's more of a guide than anything. There's certainly no penalties set out in the resolution for failure to follow the exact order of the items. So it's not necessarily that anything else will happen, and we can potentially consider it as more of a guide. But ultimately, in all cases, if the employee agrees with any position that's put forward by the employer, the risk of claims and the risk of any further action being taken is probably limited in any event. So it's probably taking a risk-based approach. And so I think consideration should be given to whatever works in the circumstances. If employees are happier doing part-time, say, than unpaid leave, possibly go down that route, and that might be a safer option in any event. The second question is, what is the process to update WPS in case of salary cut and unpaid days? So this is something that's also come up recently a number of times. And as I understand it so far, the WPS is not hasn't changed its position as it was before. So there's no way to update the WPS as to these arrangements. But clearly, if so the Ministry of Human Resources and Democratisation is linked to the WPS. If we go through the correct process with the ministry in terms of documenting arrangements that are put in place using the ministry format, the WPS issues should not arise in the same way that they would have otherwise. So I would say just use the ministry documents, get 3 copies for the reasons that I mentioned before, and then if the WPS questions the position, you've got the documents to be able to show them what's happening and why, and the fact that the employee has bought into the arrangement. Yeah, so we've also got the next question is about guidelines on how to treat the situation of workers blocked out of the UAE due to the restrictions on movement. And again, this is something that's coming up regularly. And it's an interesting one, but very much case specific. So, for example, there is, in my view, a difference as to how you might treat an employee who went out of the UAE knowing they wouldn't be able to come back, versus employees who perhaps, for example, were on a business trip and that when the announcement came, they couldn't come back, or they were sick so they couldn't travel. And so I think the approach to take is different depending on the circumstances. But very generally, if employees can work remotely, they would be doing that in the UAE anyway. So I would be tempted to say, let them keep working remotely, albeit from a different jurisdiction, if they're able to. If they are not able to, most employers that I'm aware of are using paid leave first. So they're saying to employees, this time is being taken from your accrued leave. And then after that, they're addressing whether to go on unpaid leave or not, depending again on the circumstances. So I think it's important to have a quick think about what the actual circumstances are before you're perhaps rolling out measures that apply to everyone equally. Let me see, I can see there's lots of questions, but I'm not quite sure how to open them all properly. Bear with me. So salary reductions, how would you reduce salaries? Is it a fixed percentage across the board or a stepped approach from director? There's no guidance on that. So the question is around whether the reductions would be based for each employee differently, or whether it would be across the board, and whether it would be higher percentages at a higher or more senior level in an organisation. And I think that question's probably coming from, we're seeing a lot in the news from the likes of Emirates and EMA and other organisations that are applying reductions across the board, and they're applying more significant reductions for the higher level of employee. So, for example, the C-suite, the directors, etc., are taking, I don't know, 50% cuts, and everybody else is taking 30, 20, 10%, etc. There's no guidance on that. So it's not the case that you have to follow the approach that's been taken by others. And it's not even necessarily the case that you would have to treat all the employees the same. Again, from a practical point of view, and in light of the fact that we don't have anything set out in law at this point, what I would say is if you treat all of the employees differently, so for example, all at the same level, but differently at that level, you're not going to get employee buy-in. So the reality is the more of a fair approach, or a transparent and fair approach it appears to be from the outside, the more likely you are to get employee buy-in. And I think the way Emirates and EMA and others are doing it by going giving higher reductions at the more senior level, the reason they've taken that approach is to get employee buy-in, because they can show to their employees, look, we're doing everything we can. We're not making you reduce your salary and then we're still sitting there on high salaries. They're showing we're trying to do this as well. We're all in this together. And therefore, you know, we want you to accept the position we've put to you. And the employees probably are looking at that, I would think, and thinking everyone else is doing this. We're all part of the same team, and then accepting the situation. Again, at that point, you would be required to get employee consent in writing, just to make sure everyone's happy, or everyone is at least, rather than happy, comfortable with the position, and that you have documentary proof of what's happened. So I guess the short answer is you can pretty much do whatever you want as long as you get employee buy-in, and you're more likely to get that if you take a fair approach. So the contract amendment annex, is it to be used only in case of salary reduction? No, it can be used for unpaid leave as well. So it's a very short document, and again at the top it's got ticky boxes. So what are you using it for? Is it short-term salary reduction, long-term salary reduction, or unpaid leave? So you can use it for all of those. Some companies as well, I know, have used their own template in addition to the ministry one just to add more colour to what's going on, and it's fine to do that as long as you comply with the company, the obligation to complete the ministry document. So you can have something else in the background, but do complete the company the ministry document if you are imposing any of those options. I'm also the next question is, and thank you all for all the questions. It's really good to hear what's happening, what sort of questions you have, particularly when we are doing this session in a webinar format rather than face to face, and it's a bit more difficult to be interactive, I realise, on a webinar. So I thank you for the input. So the latest question is, how long can the temporary alternatives be in place, and what's considered temporary in relation to the resolution? It doesn't say, and I realise I'm saying that a lot. Probably it's not so surprising, but the resolution doesn't go into that level of detail. But I think if we have a clear start and end date, if it's, for example, 3 months or 4 months or so, and we have a clear start and end date for the arrangements, then we can consider that to be temporary. I think if we start going, it's going to be 12 months, 18 months, 2 years, we probably have a more difficult argument to say that that's temporary, particularly because some limited term contracts will be in place only for that period. So I think anything, I would probably say a couple of months or so we can consider as temporary. Anything when it starts being, over probably even 6 months, over that, we're probably losing any argument that it's temporary. But in terms of what the resolution says, it doesn't provide that level of detail. So, and from in practice, what I'm seeing at the moment is that the vast majority of companies are putting arrangements in place for example, 30 days at a time with an option to renew. And so that's always an option if you don't know how long it's going to be in place, but you want, once things get back to normal, you want to also go back to normal on salaries, for example, then it's probably worth putting an initial period in, maybe 1 month or 2 months, and then giving the company the right to renew, of course, with employee consent at the end of that period. And that's definitely what's happening at the moment. I'm also, the next question is about recourse for employers where the employee doesn't consent to the measures that I've outlined, so unpaid leave, etc. And can that be a legitimate reason to terminate employment? The short answer is no. So if an employee doesn't agree to the measures that you're putting in place, that doesn't give an employer the right to dismiss, and that would not constitute a valid reason for dismissal. So I think it's important to, wherever possible, to get employee buy-in to any of the measures that are put in place. And ultimately, if you are in a situation where employees will not agree to the position, but ultimately they can't be paid salary, then of course that's a commercial decision for the employer as to what steps to take next. And it may be that in reality there are no other steps, there are no other options. So if the company, for example, just does not have the money to pay salaries, then it may be that it has to proceed in any event without consent. Again, it is not compliant to do so, but then see what happens, or to look at termination. But if termination is considered, then of course we would have to bear in mind the provisions of the labour law, which again continue in force as before. And so we're then into normal termination of employment. Do we have a valid reason? If not, there's going to be, or there's a likelihood of compensation being awarded to the employee. And again, that's an important factor to bear in mind in terms of cash flow, because that might crystallise amounts that are paid to an employee or owed to an employee, and it might mean that the company is actually in a worse position from a cash flow perspective. So the next question is, if an employee is terminated on notice for a reason of redundancy, does this mean the employee should claim at the ministry for full payment of all allowances? Again, we're yet to see what's going to happen with claims in relation to the resolution. So if the employer has not put the employee in the virtual job market or virtual labour market. Again, it's not clear what impact that would have on any claim. I think what's probably going to happen in that situation is that employees are likely to claim for the full payment of allowances from the date of termination until some future time. And obviously employees are going to try and have that period as long as possible. But clearly, if they're able to leave the UAE or the resolution is retracted, then that would end the time within which they would be entitled to payment. So I think that in itself will depend on, again, circumstances, but definitely employees will try to claim for that period, and will use, if the employee has not put them on the virtual job market, in circumstances where the employee has agreed their details can be placed on there, that may be considered to be a factor that the employee will draw to the attention of the courts, and could, of course, make the court less sympathetic towards the company. So it's important to try and comply with the obligations in the resolution if at all possible. So I think we have time just for one or two more questions, I think. But the next question is about so if companies have made offers to employees that are outside the UAE, how should that be handled at this point? Because obviously onboarding can't be achieved at this point in time. Again, it's a question for the company, and it depends on the documents that have been issued. Now, clearly, if the company has issued an offer letter and/or contract which provide that the job offer or ongoing employment is conditional upon one, the completion of a probation period, and two, the company obtaining certain approvals such as residence permit, etc., and the company is unable to do that, then clearly it can potentially rely on the inability to onboard the employee as a reason for withdrawing the offer or terminating the contract. Again, whether the company wants to do that, though, is a matter for it to think about, because if it's gone to the effort of recruiting and it's got the right person for a job, or sufficient, person who's sufficiently right to make an offer of employment, is it in the company's interest to retract the offer or terminate employment? And that might not always be the case. So it will depend on the particular circumstances, and I think thought has to be given also to the practicalities around that, rather than just simply whether you are legally able to do it or not. You as an employer could well probably do that, could probably retract an offer or terminate employment, but again, is it in the interest of the company? And only the company is well placed to make that decision. I think there's one more. We've mentioned that the DMCC has adopted the new resolution, and yes, that has been verbally confirmed by the DMCC, although we haven't seen, or I personally haven't seen, anything in writing yet that would confirm that. That's not to say that they haven't released anything yet, but we have had confirmation verbally that they either intend to implement the resolution in full, or they're going to adopt something very, very similar. So it might as well be the introduction of the resolution in the DMCC. So the indication at this point in time is basically the resolution will be applied in DMCC, and possibly other free zones may well follow suit. So it's important for companies within the free zones to make inquiries of their relevant free zone authority as to their obligations insofar as unpaid leave and reductions in salary and any other measures which might be taken, just to make sure that the employing entity complies with any obligations in that regard. So, and I think we're there or thereabouts on the questions, or as many as we can kind of fit in. I've got my email address on the slide now. So if there are any other questions that haven't been answered, or if there's anything else that, any other kind of pressing issues or anything else that it would be useful to talk about, then feel free to drop me an email and we can always deal with any queries offline. But for the time being, thank you everyone for your attendance today. And thank you for all the questions. It's been really helpful to hear from everybody. And again, feel free to reach out to me with any questions that you might have.